So Indian Evidence Act 1872, and there are three main principles, uh, underlying principles in law of evidence. Evidence must be confined to matter in issue. The first principle is it must confine to matter in issue. And now, what is matter in issue? Matter in issue means something, any question, any fact which is in dispute. When I say something and you say something else, so there are conflict in our facts. So that would be a matter in issue. Hearsay evidence. Second is hearsay evidence must not be admitted. What is hearsay evidence? Information coming from unreliable, unknown sources who are not sure about all the things, all the facts. And the third is the best evidence must be given in all cases. These are the three principles, main principles. These are the three underlying principles of law of evidence. Thereafter, this PDF says that judge cannot absolutely rely on the rule of evidence. Judge must, the best guide for a judge on a question is his own common sense and experience of human nature. So these are the guiding principles. All the rules of evidence act are the guiding principles, but there is no straitjacket formula that just because it is written it has to be like that. ऐसा कुछ नहीं है. ये एक रीजनेबल प्रूडेंस कॉन्शियसनेस होगी जज साहब की, जो उसके बेसिस पे वो डिसाइड करेंगे. ये डायरेक्शन उनको इंडियन एविडेंस एक्ट के अंदर मिलेगा. सो द स्कीम ऑफ इंडियन एविडेंस एक्ट, इट इज़ डिवाइडेड इनटू थ्री पार्ट्स: relevancy of fact, mode of proof, production and effect of evidence. So relevancy of fact is what fact may or may not be proved, section 5 to 55. And thereafter mode of proof deal with how are the relevant fact to be proved, that is section 56 to 100. So relevancy of fact are falling in section 5 to 55, and how those relevant facts are to be proved, mode of proof is in section 56 to 100. Thereafter production and effect of evidence, that is falling in chapters 7 to 11, from section 101 to 167. So relevancy of fact, it extends to whole of India including J&K. This is an old PDF, so that's why इसमें mention नहीं है. Further, Indian Evidence Act does not apply to affidavits presented in any court, affidavits पे and before any arbitrator also. Evidence Act apply नहीं करेगा. And it came into force on 1st of September 1872. Okay, applicability of Indian Evidence Act. Section 1 provides that applicability of this act to judicial inquiries only and not on administrative inquiries. So it means administrative inquiries में Evidence Act apply नहीं होगा, only judicial inquiries में होगा. Inquiry, when judges भी inquiry करते हैं, तो an inquiry is judicial if the object of it is to determine a jural relation between the parties, then the inquiry is a judicial inquiry. A judicial proceeding is one in a course of which evidence is or may be legally taken on oath. So an execution proceeding is a judicial proceeding, but a contempt proceeding is not a judicial proceeding. Proceeding under the Income Tax Act are not judicial proceeding. Further proceeding before industrial tribunal are judicial proceeding. Okay, so this act does not applies to affidavits, but the deponent's assertion of a fact on the basis of his personal knowledge does not constitute evidence. An affidavit is, however, used as a mode of proof. It can become evidence only by the consent of the parties or if specially authorized by any provision of law. For example, Order 19 CPC, Section 295 to 297 CRPC. Further, arbitrators have to follow the principle of natural justice and not the rule of evidence. Also, the Evidence Act has no application to the inquiries conducted by the tribunal. When tribunals are doing inquiries, then Evidence Act will not apply on it. Okay, and जो PWD की arbitration proceedings होती हैं, there are hundreds of different kinds of arbitration proceedings. They are also this evidence act will not apply. Natural justice को follow up करेंगे. Even though there may be judicial in character, such tribunal follow the rule of natural justice, just like Court of Financial Commissioner, where the excise matters goes. They also follow the rule of natural justice. Strict Evidence Act नहीं apply होगा. So lex fori means law of evidence. It is called lex fori, a law of a forum or a court in which the case is tried. Law of a place of the action. Okay, where a witness is competent or not, whether a certain evidence proves a fact or not, that is to be determined by the law of a country where the question arises, where the remedy is sought to be enforced, and where the court sits to enforce it. Where evidence is taken in one country in aid of a suit or a action proceeding in another country, either an ordinary commission or with the assistance of a local court, the law applicable to the recording of evidence would be law prevailing in the country where the proceeding is going on. For example, अगर कमीशन इंडिया में आता है किसी फॉरेन कंट्रीज से टू एग्जामिन, देन लॉ ऑफ इंडियन एविडेंस एक्ट के हिसाब से ही हम यहाँ पे एविडेंस रिकॉर्ड करेंगे और वो वहाँ पे फॉरेन कंट्री भेज दिए जाएंगे. देयर आफ्टर सेक्शन 2 रिपील ऑफ enactments. So 2(1) talks about repeal of all the rule of evidence which were not contained in the statute, act or rules in force in any part of British India. Okay, these are theoretical. The act a complete code. So is Indian Evidence Act is a complete code? It basis क्या है? English law Indian Evidence Act का basis है. It says this Indian Evidence Act consolidates, defines, amend the law of evidence. The act, however, is not exhaustive. It does not purport to contain all the rules of evidence. For the interpretation of section of this act, the court can look into the English common law. However, the court cannot import any principle of English law which is inconsistent with what is laid down in the act. So Indian Evidence Act is not exhaustive. Whenever any question arises, they can look for examples to English common law, because वही Britishers का that was the base of the law of evidence. The law of evidence is contained in Evidence Act and in other acts, statute which make specific provision on the matter of evidence. For example, CPC में order 26, section 291 to 292 CRPC, section 59 123 Transfer of Property Act, it may be noted that the Evidence Act deal with the particular subject of evidence and is a special law. Indian Evidence Act is a special law और particular subject के ऊपर ये deal करता है. Hence, no rule about the relevancy of evidence contained in the Evidence Act is affected by the provision of CRPC, because it's a special law, or any other enactment unless it is so specifically stated in the code or it has been repealed or annulled by another statute. जब तक specifically mention ना हो, Indian Evidence Act के provision पे कोई फर्क नहीं पड़ने वाला है. Evidence excluded by Evidence Act is inadmissible even if it seems essential or ascertainment of truth. There are certain facts which are not falling under section 5 to 55. We cannot prove it, although they may be very much important, but because they are not falling in the category of 5 to 55, we will not consider them as evidence which can be produced in the court of law. Further, parties cannot contract themselves out of the provision of the act. Likewise, a court cannot go on the ground of public policy exclude evidence relevant under the act. Public policy के basis पे court cannot exclude Evidence Act के provision को. Section 3 is interpretation clause, and it defines so many words which are frequently used in the act. For example, court में it includes all the judges and magistrate, all person who are legally authorized to take evidence but not arbitrator. So arbitrators are not judge, not court. Thereafter court include jury also, but it does not include arbitrator, though he is legally authorized to take evidence. फैक्ट को जब यहाँ पे एविडेंस एक्ट में डिफाइन किया है, वो कहते हैं एनीथिंग, स्टेट ऑफ थिंग, रिलेशन ऑफ थिंग केपेबल ऑफ बीइंग परसीव बाय सेंसेस, जो हमारी 5 सेंसेस से हम परसीव कर सकें वो सब चीज़ें, एनी मेंटल कंडीशन ऑफ विच एनी पर्सन इज कॉन्शियस, दीज आर ऑल फैक्ट्स. आपके ऑफिस में जो चीज़ें जहाँ रखी हुई हैं ये सब फैक्ट हैं. आप अपनी आंखों से जो भी खिड़की के बाहर देख पा रहे हैं ये भी फैक्ट्स हैं. रोड साइड पे जितना ट्रैफिक गुजर रहा है, लोग गुजर रहे हैं, ये भी सब फैक्ट्स हैं. तो एवरीथिंग इज़ फैक्ट. आपकी किसी से लड़ाई हो गई, उस वक्त आपने जो कहा, आपको जो फील हुआ, आपने फिर किसी से शेयर किया, आई फेल्ट सो डिस्टर्ब एंड अपसेट, इट्स ऑल फैक्ट. फर्दर अ मैन हर्ड और सॉ समथिंग इज़ अ फैक्ट. अगर आप कोई ओपिनियन रखते हैं, आपका कोई इंटेंशन है, उस इंटेंशन से आप कोई काम करते हैं, किसी गुड फेथ से करते हैं, फ्रॉडलेंटली करते हैं, या यू यूज़ अ पर्टिकुलर वर्ड इन अ पर्टिकुलर सेंस, आप किसी को कॉम्प्लीमेंट देते हैं या सरकाज़म यूज़ करते हैं किसी के ऊपर, ये सब फैक्ट है. फैक्ट को 2 पार्ट में इन्होंने डिवाइड कर दिया है कि फिजिकल फैक्ट एंड साइकोलॉजिकल फैक्ट. स्टेट ऑफ माइंड आपका साइकोलॉजिकल फैक्ट हो जाता है, और जो ऑब्जेक्ट्स, कार्स, बिल्डिंग्स, सिग्नल्स, फ्लाईओवर्स, ये जो है आपके सर्कमस्टांसेस में आपके चारों तरफ, दीज आर ऑल फिजिकल फैक्ट्स. साइकोलॉजिकल फैक्ट कैन ओनली बी प्रूव्ड बाय सर्कमस्टांशियल एविडेंस. फिजिकल फैक्ट प्रूव करना इट्स क्वाइट इजी. सीसीटीवी फुटेज आप लेके आ जाओगे, आप आई विटनेसेस लेके आ जाओगे, फोटोग्राफ्स लेके आ जाओगे आप, लेकिन सर्कमस्टांशियल एविडेंस के थ्रू ही आप साइकोलॉजिकल फैक्ट्स प्रूव कर सकते हो. फैक्ट्स में भी पॉजिटिव और नेगेटिव ऑल्सो. एग्जिस्टेंस इज अ पॉजिटिव फैक्ट एंड नॉन एग्जिस्टेंस इज अ नेगेटिव फैक्ट. एक बड़ी इंपॉर्टेंट चीज़ है फैक्ट एंड इशू, जिसके चारों तरफ इंडियन एविडेंस एक्ट रोटेट करता है. इट इज़ कॉल्ड प्रिंसिपल फैक्ट और फैक्टम प्रोबेंडम. It means an act from which either by itself or in connection with other fact the existence, non-existence, nature or extent, nature and extent, where it have gone, nature and extent of any what, nature and extent, existence and non-existence of what, any right, any liability or disability जिसको आप एजर्ट करते हैं, डिनाई करते हैं इन एनी सूट और प्रोसीडिंग, सूट में या प्रोसीडिंग में, नेसेसरीली फॉलोज एनी फैक्ट एजर्टेड और डिनाइड इन आंसर ऑफ सच इशू और फैक्ट रिकॉर्डेड अंडर अ सिविल प्रोसीजर कोड. द फैक्ट इज कॉल्ड प्रिंसिपल फैक्ट, फैक्टम प्रोबेंडम. इट इज़ अ फैक्ट विच इज साउट टू बी प्रूव्ड. जो आप अपने फेवर में प्रूव करना चाहते हो और अगली पार्टी अपने फेवर में जिस बात को प्रूव करना चाहते हो, वो है फैक्ट एंड इशू. जो भी डिस्प्यूटेड क्वेश्चन आ जाएगा, दैट इज फैक्ट इन इशू. और उसी फैक्ट इन इशू के ऊपर सेक्शन 5 to 55 रोटेट करेगा. इंडियन एविडेंस एक्ट अप्लाइज ऑन फैक्ट इन इशू एंड रोटेट अराउंड इट ओनली. देर आर सर्टेन इलिस्ट्रेशन ऑल्सो. पूरे एविडेंस एक्ट की इलिस्ट्रेशन है, एक एक इलिस्ट्रेशन आपको मतलब नॉलेज में होना चाहिए, रिवाइज करते रहना चाहिए, बिकॉज बेयर एक्ट इज द बाइबल. इट इज सेड thousands of time to us. So A is accused of murder of B. At the time of trial, the following facts may be in issue: that A ने B को मारा है, या A का इंटेंशन था कि B की डेथ हो जाए, या A ने ग्रेव एंड सडन प्रोवोकेशन रिसीव किया था B से, that at the time of doing that act which causes B's death was by reason of unsoundness of a mind incapable of knowing its nature. A ने B को असॉल्ट करते वक्त A की स्टेट ऑफ माइंड ये था that he was not aware कि इस एक्ट से जो उसको पता नहीं असॉल्ट था, B की डेथ हो सकती है. So A का स्टेट ऑफ माइंड इज अ फैक्ट एंड इशू. This every fact which a plaintiff must prove in order to get an adjudication in his favor, or which a defendant must prove to defeat the suit, becomes a fact and issue. Fact and issue will depend upon the provision of substantive law applicable to the offense. जैसे for example, the action is for the tort of negligence. Such of the ingredient of liability for negligence which are in dispute shall be fact and issue. Thus, fact and issue depend upon the ingredient of an offense and state of parties pleading. So, fact and issue, there is no straitjacket formula. It will vary definitely in every case, in every circumstances. In criminal matters, the allegation in the charge sheet continue the fact and issue. In civil matters, the process of ascertaining fact and issue is known as framing. जिस चीज़ को हम क्रिमिनल लॉ में फैक्ट एंड इशू कहते हैं, सिविल लॉ में हम कहते हैं फ्रेमिंग ऑफ इशू ऑफ फैक्ट under CPC equal to fact and issue in Indian Evidence Act. Thereafter comes the relevant facts. Section 5 to 55 में जो fall करते हैं, fact logically connected with fact and issue 5 to 16, admissions and confessions 17 to 31, statement by non-witness 30 to 33, statements under special circumstances 34 to 37, judgment in other cases 40 to 44, opinion of third persons 45 to 51, expert opinion and all, evidence as to character 52 to 55. These all those facts which are falling in these circumstances, in these sections, are relevant fact, and anything beyond these sections are not relevant, and those things which are not relevant, those things are not evidence and not admissible in evidence. Relevancy of fact does not define what is the meaning of relevant, but they indicates that one fact become relevant to another, normally when it is falling in section 5 to 55, which are necessary for a proof or disproof of fact and issue. Thus, relevant fact or evidentiary facts, factum probans जिन्हें कहा जाता है, are those which have certain degree of probative force. Relevant fact are not themselves an issue, but are foundation of inferences regarding them. So relevant fact are not fact and issue, but relevant fact are very much important to prove fact and issue. Example है, when A is accused of murder of B, the relevant fact are A has motive and an opportunity to kill B. He had made preparation by buying a knife, or after murder he was seen running with blood-stained knife in his hand. So these are all his act of running is his act of buying a knife, and his act of running with blood-stained knife is a relevant fact. In order to prove the fact and issue that whether A killed B. So relevancy implies relationship, that any two facts to which it is applied are so related to each other that according to common course of event, one taken by itself or in connection with other fact proves or renders probable the existence or non-existence of a other fact. The circumstantial evidence is evidence that relates to facts other than those in issue. So circumstantial evidence क्या होते हैं? सर्कमस्टांशियल एविडेंस को आप जो है मेंटल फैक्ट्स होते हैं, मोटिव एंड इंटेंशन, और उनकी एक्टिविटीज़ के बेसिस पे ही आप मोटिव और इंटेंशन को प्रूव करोगे या डिसप्रूव करोगे. सो व्हाट इज़ रेलेवेंट, that is admissible, and what is not relevant, that is not admissible. So I'll continue with evidence, meaning and other facts about evidence in next session. My name is Pallavi. If you like and if you want something else to be discussed, please message me.